I'm Ben Myers with Ask4TR, located at www.ask4tr.com. Joining us today is James Bolden, a pretrial case manager with Ramsey County District Court. James, welcome to the show.
Thank you, Ben. It's a pleasure to be here.
You know, I want to thank you for coming in. You have an extraordinarily important job with Ramsey County. That is that you're a pretrial release officer. You specifically look at each and every individual that passes through the Ramsey County District Court in determining whether or not they have a high or low likelihood of returning for court. Is that correct?
That is correct, Ben, in part.
So now tell me what you do in general.
Interview people, get some demographics. I ask, like, how long have they been in the state, at their current address, their age. I get a record check on each individual that gets locked up.
And when you say a record check, you're talking about a background check.
Background
right?
record check.
So
yes.
To determine their prior criminal history.
That
right?
is also correct.
And now you also look at not just their criminal history, but also whether or not they have any prior bench warrants. Is that right?
Absolutely.
Now, just to be clear so that people understand what a bench warrant is, can you tell us what that is?
A bench warrant is when you were given a notice to return to court,
right,
and you were given that notice in court, in your hand. Mm-hmm. If you do not show up for that, then you are issued a bench warrant, and they'll come and pick you up, or they'll pick you up whenever they see you.
So then what I understand is that in determining whether or not the person that you're currently interviewing has a high or low likelihood of returning to court, you look at bench warrants, prior criminal history, whether or not they have a job,
yeah,
and other collateral contacts. Is that right?
We do. The collateral contacts is basically just to get verification of their address. The address that they give us, let's say, for instance, a person says he lives at 2020 Thomas,
right,
and we're gonna verify that. And hopefully they have someone's name and number that we can use to call to verify that.
Now, once you go through this entire process, let's say that it's well, just back up, you handle misdemeanor, gross misdemeanor, and felony type cases, correct?
That's correct.
And so when we talk about misdemeanors, we're talking about maybe a first-time DWI or maybe criminal damage to property that has a low amount of damage done to the property. Is that right?
Yeah, but we also do transit crimes. Excuse me. Say, for instance,
what's a transit crime?
I'll explain. Transit crime is when an individual jumps on the train or the bus, mm-hmm, and does a ride without paying.
Oh, okay.
And which is, I have a problem with arresting people for that, but yeah, we do those as well.
Now, obviously, you're giving me a segue in. Why do you have a problem with transit crimes?
Well, because the train runs through the heart of the if I may say, the ghetto, where people are trying to get from point A to point B, and they don't always have monies to pay for a ride. But you can get on the train without paying, and the only time, and you can get off without paying, but sometimes they'll check to see if you've paid, they'll see if you got a ticket or whatever, and if you don't have a ticket, then
you'll get one.
Yeah.
You'll ultimately get cited for not paying whatever the amount of money is. You'll be cited for that. So maybe the ticket is what, $3, $4. You'll then be given a citation for not paying that $3 or $4, which will result in you having to go to court soon thereafter, right?
Yeah, a lot of times they're in custody for that crime.
They take them
that.
Wow.
Yes, absolutely.
Now, are those considered petty or misdemeanor offenses?
Misdemeanors.
And now, from your understanding, what's the consequence if you commit a misdemeanor offense?
A misdemeanor, it depends on the charge. You can have a domestic assault. It can
right.
be a misdemeanor or a gross misdemeanor or a felony,
right.
obviously, you know. And the penalty is going to be different. It depends on how many you've had. You know, if you know, it's a enhanceable offense.
Correct.
The domestic.
So essentially, you get one domestic, it's a misdemeanor. You get another one, it gets enhanced to a gross, and then if you keep on keeping on, you are looking at a felony where you're going to prison for a year and a day or longer, right?
Potentially, yeah.
And then you look at the misdemeanor, you look at 90 days and $1,000 fine. Gross misdemeanors is a year plus or a $3,000 fine. It just goes from bad ultimately the worst. It sounds like.
And you know more about the penalties than I do.
I know a little thing about it, but what I find intriguing and what I want to go a little bit deeper in is these transit crimes. The transit crime specifically sounds like if it's going through the ghetto, it affects a disproportionate amount of people, specifically those being African Americans, than
people of color, yeah.
People of color. And when we say people of color, when you say people of color, what are you referring to?
Asian, the Hmong population.
Which is a large segment of St. Paul or Ramsey County.
It is. Latino and African American.
Now, when you see that, do you see, even though we've agreed that it's a disproportionate amount, do you still see white transit crime?
I don't know that you're going to see a lot of white transit crime, not to the proportion that you would see African American. It's primarily African American.
But statistically, and even though you may not have the statistics on you, we can agree that Ramsey County is still predominantly white. Is that fair to say?
I would say yes.
But we're seeing a disproportionate amount of African American or people of color being cited for transit offenses.
Sure, yeah.
So when something like that happens and they are taken into custody, what's the next step, especially being a pretrial case manager?
Yeah.
What's the next step that you see these people at?
Let's say a person is arrested on today,
right,
being Saturday. They'll be held over until Monday for court.
Right.
They'll be interviewed by someone from Project Remand. Well, someone from Project Remand is working over the weekend, running records, as we say, and that's getting their background.
And just let me interrupt you.
Yeah.
So when the background checks are being ran, they're being ran to determine whether or not, when they do come up for court, whether they're a high or a low risk to return to court. Is that right?
Yeah, that's pretty much what it is.
I mean, is there anything else that these reports would be generated for?
Well, the judge wants to know as much about a person as he can when he starts to make his decision.
Right.
So,
right.
I guess, yeah, pretty much what you were saying, that want to know if he's high risk, low risk, medium risk, no risk.
So then back to what you're talking about. So these reports are ran. Then what happens during this normal process?
So once we generate the report, we make the recommendation. We calculate the score.
Now, when you say recommendation,
yeah.
You're talking about the recommendation that you make to the district court as to whether or not this person should pay bail, be released on their own recognizance, or have some form of condition
yes.
that they have to satisfy in order to get out of custody. Is that right?
That they have to agree to. Yes.
That they have to agree to.
Yes.
Okay, keep going.
Yeah. So once we make the recommendation, whether we recommend bail,
right,
conditional release, or be released on their own recognizance, we give the prosecutor, the defense, and the judge a copy of the report with the recommendation.
Now, you made a comment a minute ago about there being a public defender involved. And it sounds like the public defender has a substantial impact on people getting out of custody. Now, when you make a determination on whether or not this person should be OR'd or released on their own recognizance, or a conditional release or bail, do you take into consideration that they have a public defender versus a private attorney?
No.
Okay, so then what I'm hearing you say is it doesn't matter. If they have a private attorney that comes in and says, hey, I've known this guy, represented this guy for 100 years, it does not make any, it doesn't make any, it doesn't
change my recommendation.
Okay, so nothing changes as a result of having a private defense attorney?
No.
Okay, so now when you see all that, you make your recommendation, what happens next in the judicial process?
They wait to be called.
Okay, and a lot of people that are viewing this program right now don't know what happens after that. They usually just go into the system and they're told they have bail or not.
Yes.
But there's usually a hearing. Usually it's called an arraignment or a first appearance.
Arraignment or first appearance, yes.
So what happens at that first appearance process?
At the first appearance, they will they find either probable cause or they don't find probable cause, and
what happens if they don't find probable cause?
Then they release the defendant.
But they're still charged and they still have to come back at a future court date. Is that right?
No.
Okay, so the case is ultimately dismissed.
That would be dismissed.
Okay, so if it's not dismissed and the judge hears and says, hey, it looks like this case has probable cause. They need to be told a new pretrial date or a new arraignment date. What is pretrial release's role in that particular process?
Pretrial can monitor cases for the court just the same way that probation does, except for pretrial is just what it is. It says pretrial,
Right.
and probation is post-trial after there's a guilty plea or a finding of guilt. And
Or some form of disposition. It can even be a state of adjudication, and it's monitored by probation, which is not your department specifically.
Not at all.
So you guys, as pretrial release managers or case managers, only deal with the determination of whether or not they come back for court in the future. Is that fair to
yes.
say?
We'll monitor the case through the court process.
Now let me turn your focus to domestic assault cases. Is that more involved than other, for example, transient crimes or other non-violent offenses?
I think when you have a domestic case, you're going to end up with more conditions to be released. That's if you don't post a bail, then the conditions of your release will, you have more conditions to your release. No contact orders.
And that's no contact usually with the victim or no contact with somebody who's involved in that particular
Usually with
that
the
particular
victim.
case.
Usually with the victim.
So now,
If it's a domestic assault.
Right, and your agency monitors that up until disposition, correct?
That is correct.
So now, what happens in the process when somebody violates their terms of release? Let's say they're given a conditional release and they violate those terms.
With probation, it's the same. We'll do the same thing the probation does. We notify the courts and let them know that a person is in violation of the conditions of their release.
So Susie Q's out there. She's charged with domestic assault.
Yes.
Susie Q's told that she can't have any contact with Bill Jones, but Susie Q decides to have contact with Bill Jones, and they're found together. What happens when law enforcement comes up and finds Susie Q and Bill Jones together? What happens from a pretrial release perspective?
Typically, a report would be generated requesting that the courts violate that conditional release.
So looking at it more from a logistical or a pragmatic perspective, the officer observes this. They see what the order says. The order specifically says these two individuals can't have contact, and it's on Susie Q not to violate that order. Does the police take her into custody, or do they just simply let them go about their business and issue a report allowing your agency?
That individual should go into custody.
Okay, so when they're taken into custody, what happens after that? Is it the same as an initial appearance or an arraignment?
Well, they have a new charge, so it'll be it will be the same as the initial process when they first came in on the previous domestic. So it would be a different charge.
Right.
You know, it'd be a violation of an order.
That's a court order.
It'd be a violation of the no contact order, which is a court order.
Okay.
It's court ordered by the judge, and so there's a new charge, and the person would have to be arraigned on that charge.
So now let me ask you this: what happens in a situation similar to that of a domestic assault when the condition is no contact between these two individuals, and one of the individuals that's supposedly being protected by the order calls in and says, "Hey, this guy or girl violated the court order"? What happens when it comes to the wheels of justice starting to turn, based just on a phone call, alleging a violation? What happens with your agency?
It varies.
Okay.
It varies from case manager to case manager, from case to case. People can decide to contact people involved and to make sure that they have credible information that they receive from parties.
And that information is determined by your agency?
Not necessarily.
So law enforcement?
If a police report is generated and charges are filed, then it's legitimate.
You know, that's extremely important information, and I want to thank you for that. And we'll be right back with Ask4TR, located at www.ask4tr.com.
For the record, proof to show the truth. 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 For the re
And we're back with Ask4TR, located at www.ask4tr.com. Our guest again today is James Bolden. We've previously been discussing the issue of pretrial release. James, thank you again for coming in. The last segment, at the end of the last segment, we discussed the process of pretrial release. Is that right?
That is true.
So now let me ask you this. After the pretrial release process occurs, and that is when somebody's brought in after committing a crime or alleged to have committed a crime, they're given a score or a number to determine whether or not they have a high or low likelihood of returning to court. Now, once that number has been determined by your agency, there's a whole host of additional hearings that they have to go to. Is that right?
That is correct.
So tell us about that process after they're initially arraigned.
After they're arraigned and the judge can ask if it's a misdemeanor or a gross misdemeanor.
Or a felony.
Well, I need to separate those out for for my response here. Is if it's misdemeanor or gross misdemeanor, they can plead guilty at their arraignment.
Right.
Felonies, you don't. So if they plead guilty at their misdemeanor or gross misdemeanor arraignment, first appearance, if it's a misdemeanor, they get sentenced on the spot.
Right.
And then they're done. They get their sentence. Either they get probation or stay time or
some actual jail time.
Or
right?
some actual jail time, correct.
And now looking at that particular process, if they are going to plead guilty at that initial appearance,
yes.
Is it fair to say that the judge or the court would use your report that was generated to maybe use that in order to determine their penalty?
I think they more use the complaint.
Okay. The actual allegations of the crime.
Yes.
But I guess what I'm thinking of is if they have the complaint and the crime is laid out in that complaint, they may look at their prior criminal history. For example, if your report shows that they had a criminal damage to property and they're there for a trespassing, they may use their prior criminal history to determine or set that potential sentence.
Well, they will use the prior history.
Okay.
But typically the prosecution, city attorney, county attorney,
right.
Will have that information that they have generated themselves
at that initial appearance.
At that appearance, yes. It'll all be in their file on that defendant.
So now, if they don't plead guilty of that initial appearance,
yes,
and they move forward,
yes,
what does that look like? Not just from a pretrial case manager perspective, but from a defendant's perspective.
So if a person pleads not guilty
right.
at a misdemeanor arraignment, first appearance, they'll be further continued to another hearing. That hearing would be a pretrial.
And that's for misdemeanors.
That's for misdemeanors.
And if they commit a crime that was classified as a gross misdemeanor, they would go to what's called an omnibus hearing.
That is also correct.
So then what happens from that point forward?
The defendant will be released either by posting bail or conditional release, where their case is monitored by agents from the courts, which I do some of that.
Right, and that's your agency. Your agency is the one that would determine or give the court the information of whether or not they should be released with conditions, bail, no conditions whatsoever. So they're given that information, and then they move forward in the process to the next court date.
Correct.
All right, so give us the perspective from not just a pretrial case manager perspective, but the perspective of a defendant when they're now out of custody, moving forward in this process, given a new date to return to court.
Well, that can be kind of difficult for the defendant. Some of our defendants are homeless. Some of them don't have phones. They don't have an Obama phone, or they don't have a place to live or to store their belongings. So they lose their order to report for court, and
not everybody has Outlook, so they can actually pull it up on any location. They can't actually say, okay, well, I lost my phone, I lost my BlackBerry, I lost my everything else. I can't just go to a public computer and look it up.
Right.
They have no place and no knowledge to come back to court.
They don't know what that date is, and
Right.
there's no one to call. Well, they can call the public defender's office.
But what's the likelihood of the public defender telling them their next court date?
Well,
Or taking their call.
If they get someone online, they can pretty much pull it up and get their court date.
You say online, you mean on the phone line?
Yes.
Okay.
Yeah. So I mean, it's a struggle for the people that we serve. That have another court date.
Right.
So I think having pretrial to be a part of that process is helpful to the defendant, because we're going to remind them of their court dates. We're going to let them know, here are the conditions. You have to make sure you're abiding by these conditions. Right. And to help that person through the court process without a pretrial agency in any county, any city in this country, I think it makes it very difficult for the defendants the people of color, right, that have limited resources to get through the court process successfully without getting a bench warrant,
Right, and the bench warrant would result as a result of them not coming to court.
Correct.
But now, looking at it from a federal or an entire U.S. perspective, we see a disproportionate amount of minorities not being able to report because of the lack of tracking with pretrial release. Is that fair to say?
I don't know that that's the cause,
right?
Because we've had that problem forever and ever.
And now, are you familiar with the federal process at all as it relates to pretrial release?
I'm not familiar with the federal process.
Because what I've heard, and I guess I'll bounce this off of you, is that what pretrial release is doing in the federal process is they're making it much more accessible for defendants to be able to be released without forms of bail, but this court is requiring that they also provide alternative forms of communication, requiring that they provide additional addresses so that pretrial release can actually stay in contact with the alleged offenders. Which is interesting, because I find that the federal process really mimics your agency's process.
If that's what they're doing, then yes, they are.
And you guys, from a Ramsey County perspective here in Minnesota, you guys have been revolutionary in trying to maintain contact, not just with offenders, but people of color in generality, because you understand that it is difficult for minorities based on the fact that their residence is not as stable as white offenders. It's not as clear cut as it relates to maintaining contact as it is with offenders like Caucasian individuals. Is that fair?
That's fair, and to go right along with that, Ben, is our people of color don't trust that the other, what would you call it?
Well, I don't think they trust the process.
They don't trust the process. They don't trust the system.
I think people of color in generality do not trust the judicial system. And what's refreshing from my perspective is looking at you, knowing you for so long, that your dedication is not just to African Americans or whites. It's about the credibility and making sure that the judicial process is accessible to everyone.
Yes.
In fact, I've worked with you for quite some time, and that's the one thing that's been very clear to me, that you are fair, you're clear, and you want people to make sure they make their court appointments.
Absolutely. Absolutely.
So understanding that court appointments are so important, making sure they come back to court, let's focus in on that pretrial omnibus hearing, or that preliminary hearing that lends itself or leads up to the actual trial itself. Tell me, from your perspective, whether it be from a racial history or whether it be from any specific type of demographic, how do you make sure these people come back to court?
Like you mentioned earlier, I try to get information, contact information, address, family, collateral numbers where I can call the family member if I can't reach my defendant, if their phone is shut off, if they don't have a phone. I'll send a letter to the last known address to try to keep them in compliance so they get through this process. That's me. That's James Bolden.
Right.
That makes every effort to get these people through this process without getting another negative mark.
So despite whether you believe that they're guilty or not, your objective...
Don't care.
Don't care. Just get them through this. That makes me so proud. It really does. It reaffirms my belief in the system. And thank you very much. That's incredible. I appreciate that.
If I may add one other thing,
absolutely.
Mr. Meyer. If a person can get through the process and know that there's someone there to help them get through that process, then we win. They start to build trust in the system that maybe I can find someone there that I can rely on, that I can rely on to help me through the process or whatever I may be doing.
Absolutely, and I appreciate that. And we'll be right back with James Bolden at Ask4TR, located at www.ask4tr.com.
For the record, proof to show the truth.
I'm Ben Myers with Ask4TR.com. I want to thank Mr. James Bolden for being in the studio today, talking about the specific issue of pretrial release as it relates to Ramsey County as well as throughout most states in this country. James, thank you so much for joining us today.
You're welcome. I was glad to be here.
This is extraordinarily important information, and hopefully that everyone out there has seen this will appreciate the information. If you have any additional questions for myself or Mr. Bolden, please send those emails to info@ask4tr.com. Again, that's info@ask4tr.com. And that concludes our time today with Mr. Bolden. Take care of yourself.